Josh Hammer, thanks for joining. It's always good to see you.
My pleasure. Thanks for having me again, Sean.
Yeah, so you're up there at Yale. This is going to be a fun night for you, huh?
Yeah, look, I mean, it's always crazy when you go to the Ivy League these days, but Sean's not my first rodeo. It should be a fun one for sure.
Good. Well, get some pizza in the New Haven area. I'm sure that'll be good. I want to start, lots going on, but one of the things that I, as a non-lawyer, have been interested in is this whole Trump third term idea that was floated. He talked about it the other day on Air Force One, teasing the press that a lot of people are talking to him about it. I know they blew it out of proportion and said, oh, he's saying he's running for a third term. He didn't. But the funny part about this is that I went back and read the 22nd Amendment. And we'll put it on the screen for folks. But here's what it said. No person shall be elected to the office of president more than twice. And no person who has held the office of president or acted as president for more than 2 years of a term to which some other person was elected president shall be elected to the office of president more than once. But this article shall not apply to any person holding the offices when the article was proposed proposed to Congress, and should not prevent any person who may be holding the office of president or acting president during the term within this article from holding the blah, blah, blah. So the first part of it, though, the one theory, and again, I just want to be clear with you, Josh, I don't buy into this. Like the idea of somebody but the theory goes like this. J.D. Vance would run. He'd get sworn in as president. Trump would be his vice president. And then he would immediately resign. Trump would be president again. So just from a legal standpoint, would that be possible?
Okay, so like many legal questions, Sean, that have come up ever since 2017 when Donald Trump took power, we would be in uncharted waters. I mean, but we've been in uncharted waters before. I mean, this would not be the first time, one way or the other, that we've been down a certain rabbit hole. I mean, the shoe has been on the other foot.
But just walk me through. Here's the thing, Josh. I get the uncertain thing, but I'm a non-lawyer, right?
Yeah.
Okay, and I read this, and it says no person shall be elected to the office of president more than twice. He wouldn't have been elected to the office. He would have been elected twice, and then he would have been elected VP once. And it says or acted but it doesn't say anything about ascending to the presidency.
Right. That's exactly right. So the 22nd Amendment text does not speak of that. So look, I mean, Sean, like you, I am skeptical. I am not necessarily one who is pushing this sort of talk. I'm not necessarily pushing, frankly, Donald Trump to do this. But I suppose the argument, I mean, if I'm going to steel man the case, as they say, if I'm going to present the strongest possible argument of this particular position, I think the argument is that if he were to not necessarily be vice president, I mean, he could theoretically be the Speaker of the House, frankly. There's actually nothing in the Constitution that requires that the Speaker of the House actually be a sitting congressman. This is actually also a talking point. I've heard Newt Gingrich talk about this over the years there. So in theory, he could be named Speaker of the House, which is pretty high on the list of presidential succession there. And then come 2028, let's say, hypothetically, it's President J.D. Vance, Vice President Pete Hegseth. I'm just making that up, okay? And then hypothetically there, if you get a couple of resignations there, then perhaps he could ascend to the presidency without ever having been elected, whether on the presidential slate or the vice presidential slate there. That is the theory of the case. I think that is the steelman strongest possible argument there. It's not obvious to me that would be a textual, literal violation of the 22nd Amendment text, assuming that he were to serve probably fewer than 2 years, right? Because there is kind of that 2 years of the four-term qualified there in the 22nd Amendment there. But even if it doesn't violate the literal text here, Sean, if I'm just being very candid with you, that's not necessarily how constitutional interpretation works. We don't necessarily do things literally. You're trying to figure out what the meaning is, not necessarily what the literal words meant absent context. So this kind of gets into a legal interpretation, a bit of a semantical debate there. That's what lawyers do. Obviously, we like to debate over words and meaning, so forth there. I'm skeptical. I'm a skeptic of this. I am not a huge proponent of this, but I think what I laid out is probably the strongest possible case that this could possibly take the shape of.
Yeah, I mean, look, there's a bunch of other scenarios. He could get named Secretary of the Treasury, and then the cabinet, everybody resigns. I mean, but I think to me, I think this is a silly thing that he loves trolling people with.
Yes.
But it's just funny because so many of the folks in the media reflexively just go, it's impossible. And it's like, again, I'm not a lawyer, but I go, that's not how I read the 22nd Amendment. I get your point about how it might be interpreted. But I also have a hard time thinking that the Supreme Court would weigh in and say, technically, he didn't, I mean, I don't know. I think it's fascinating. All right, let's move on because I think we've definitely debunked that it can't happen, but also probably that it politically won't happen. So now let's move on to something that's interestingly equally intriguing to me. Ed Martin, who I actually saw this weekend, as a matter of fact, he is the interim U.S. attorney in the D.C. area. He is apparently, according to news reports, pursuing an inquiry into whether that Biden was competent when he pardoned, all of these family members at the end. And he has sent letters, according to reports, to Jim and Sarah Biden, and then he's asking Jeff Zients, the former White House chief of staff under Biden, whether the Biden was aware of the breadth of the pardons. And so my question to you is, again, I had this conversation with a couple lawyers about, even Alan Dershowitz, about what the president, whether he has to sign things or not. And there's, I think, a lot of folks that believe that the Constitution makes it clear that you have to sign bills. But when it comes to pardons and other things, there's a lot more latitude there. I as a lawyer, what possibilities, like what could possibly come of this?
Okay, so another interesting question, Sean. Part of the reason why I love going on your show, Sean, is that you ask me the most interesting legal questions out there, right? So, I mean, this definitely is a very interesting, another kind of uncharted water legal territory situation there. We haven't had a president who has lost his mental capacity like Joe Biden has probably since Woodrow Wilson over 100 years ago, right? I mean, it's been a very long time, certainly. So this definitely is a different situation there. So the Con Law 101 answer, the constitutional law school classroom answer would be that the plenary power, that the pardon power of the president is plenary, that it is absolute, that there are really no qualifiers there, and that if it is his signature on the page, then it is done, period, end of story. That is probably the most common answer that you would find there. However, there is a creative legal argument, again, if I am going to steelman this, so to speak, and the argument basically says that whenever a signature is affixed to a document, whether it is a private contract between parties or whether it is a public statement such as signing a bill into law, there does have to be some sort of subjective intent there. In criminal law, we would call this mens rea. It's the Latin term referring to what your subjective mentality is at the time of a criminal act. So too, in contract law, for instance, the common law of contracts, if you do not actually intend something in your mind there, the contract could be torn up by a court as being illegitimate. So it's basically taking that and trying to apply it to the pardon power. That is the theory of the case that I think Ed Martin's getting at. I happen to be a big fan of Ed Martin, by the way. We're big proponents of Ed Martin at the Article 3 Project, where I'm senior counsel, and I very much personally hope that he gets to be the full-time U.S. attorney. I'm not fully sold on this argument, but I think it's a very interesting case. I saw Tom Cotton, who's also no legal slouch himself. Tom Cotton has been pushing this theory a little bit there. I think it's worth trying. I mean, you might as well just...
Do you? I see. This is where I listen. I've known Ed a long time through my time at the RNC. I worry about the slippery slope that we go down with this. I get why we're doing it, but I worry that this comes back to bite us in the butt.
How can you spell that out a little bit, Sean?
Because you start going down the line of like, you go down what was Reagan's state of mind at the end of his term? What did he know? And we obviously can't find that out because he's no longer with us. I just wonder. I had a very interesting conversation with a lot of lawyers, first with Alan Dershowitz and then several folks about this whole idea of signing a bill and not. And I guess my question is, if we start saying who knew what when, I mean, here's the obvious answer. I don't I'm I think everyone knows where I stand politically, but I feel like all you need to do is pull Joe Biden out. Did you know about these pardons? He's going to go, yep. And it's like, okay, the Constitution, to your point, gives a lot of latitude when it comes to these. And I think if we start going off, well, what did you know when? Were you sick then? Were you out of the country? We're going down a slippery slope about what the president knew at the time something was signed, and maybe something was auto-penned. And you go, well, technically he wasn't aware of that at the time because no one informed him about the appointment of Josh Hammer to, this great appointment to the Supreme Court. And suddenly we start going down this rabbit hole of what was legitimate, signed, and not. What did the president know? Again, maybe this is where not being a lawyer, maybe I just don't get the full implication of this, but I worry that we're going down a path that opens up a bunch of did the president know at the time X was being signed?
No, I think you understand it perfectly well. It's an extremely valid concern. Look, my general approach to this whole, if people on the right do it, then people on the left do it, because this comes up over and over and over again, right? Unfortunately, we live in a day and age where the gloves are frankly off, and the norms have been shattered by the very people who profess and purport to care about the norms in the first place there. So I mean, I personally stopped kind of taking this particular strand of argument seriously when there was the FBI raid in Mar-a-Lago, things like that. When Alvin Bragg started prosecuting the former president of the United States, now yet again the president of the United States there. That to me is when kind of this general approach of, oh, if the right does it, then the left may do it too. I generally just am not sympathetic to that particular argument anymore at this time. Having said that, Sean, having said that, to your point there, I am actually skeptical of the substantive legal argument that the president's mental capacity there does affect the legitimacy of the pardon. So I'm not necessarily concerned.
Well, I only
about
say that the only reason I say this is just, again, let me just be clear on this for everyone who's wondering, is that how do I know what his mental state was 8 months ago? So you interview Biden today and he goes, oh, not a joke, folks, not a joke. Uncle Ted said, like, that you won't know what it was 8 months ago. And to ascertain that, from somebody who's clearly in mental decline, what the state of mind was at the time that they did that. And I get your point. Like, I think about people who've they talk about this with conservatorships. What was their state of mind when they were put in one? What was the state of mind when someone signed a legal document buying a house or giving away their estate? I've seen enough of that. But anyway, I do worry about, because somebody could have had COVID or been sick, and you go, well, what was their state of mind when they signed that piece of, all right, let's turn for a second, if we will, to what's going on in the federal government with respect to DOGE and all this. And again, walk through this from my perspective as a guy who reads the Constitution. I did take Con Law 101, by the way, but that was the extent of it, and it was 30 years ago. But there's a story out that says DOGE on SCOTUS watch. DOGE has racked up a string of losses in the lower court. Now it's time to find out if it has better luck at the highest court. In the coming days, the Supreme Court may issue its first substantive decision on the Trump administration's effort to dismantle the federal bureaucracy. And these initial rulings will signal how the justices view this thing. 2 emergency appeals from the Trump administration on DOGE-related issues are now pending. In the first case, the administration wants the justices to lift a lower court ruling that is blocking the Department of Education from immediately terminating $65 million in grants. So for me, I look at this and say, he is the executive. He's the head of the executive. And there's money out there. He doesn't think it's being well spent, and he's stopping it. Why doesn't the president have theoretically absolute authority when it comes over the executive branch and the money?
Well, in my opinion, he does. I think that's a winning argument. I mean, there is one person in our constitutional structure who is vested with the executive power, and that's the president of the United States. Back during the Bush administration, Sean, people tried to say, oh, this thing called unitary executive theory. It's like a John Yoo, Jack Goldsmith legal theory. It's so scary there. It's literally just a simple textual observation based on Article 2, Section 1, Clause 1. One person has the executive power. It's not the vice president. It's not the attorney general. It's not the coffee fetcher. It's the president of the United States there. But the president of the United States, in exercising the executive power, can delegate to lesser people to issue strong recommendations then that ultimately come to his desk there. That's basically what DOGE is. I view the whole DOGE phenomenon, this Department of Government Efficiency, as being very similar to, let's call it the Domestic Policy Council, which is a fairly recent phenomenon in American history. It's only three and a half decades old or so, the Domestic Policy Council. But they're right there in the Eisenhower Executive Office building. It's kind of the building right next to the White House for those who are not total Washington, D.C. political nerds there. And these guys can issue very strong recommendations on the president's behalf to the executive branch that the president has plenary control over there. So it seems to me to make a lot of sense. I think that a lot of these anti-DOGE activists are ultimately going to lose at the current Supreme Court. The current Supreme Court, I get a little wobbly sometimes when it comes to these so-called cultural issues. But when it comes to bread and butter, structural separation of powers issues, what does Article 1 mean? What does Article 2 mean? What does Article 3 mean? Arguably, that's the most important part, actually, on the nationwide injunctions, Article 3. But sticking to Article 2 for a second there, I feel pretty strong that this Supreme Court, as presently constituted, understands what the executive power means and what it entails. And he certainly has the ability to pull back as much funding as he wants to within his executive branch. Now, if it comes to something different, such as outright abolishing a congressionally, statutorily created department, such as the Department of Education, yes, you will technically need a statute in order to literally abolish that. But that doesn't mean that you cannot accomplish the same, essentially very close to the same thing via just attrition and firing lots of staffers there. In order to literally shut down the building, right, you would probably need an act of Congress because the education department was created by statute back in 1979 during Jimmy Carter. But you could essentially strip it of all funding and fire as many staffers to all but end it, basically immunizing the formality of that. So the executive does have a lot of power here for sure.
So the way I look at this, let's just say that there was a report today that said that the Department of Education was taking grant money and literally throwing it out the window. They cashed the checks and they're throwing it out the window. If the president of the United States said, I called over and I said, stop throwing that money out the window, put it back into a thing and I'm taking it away, nobody would object, right?
I mean, you'd be absolutely out of your mind to object to that. I mean,
right, but I think that like we wouldn't be having this conversation if right. So the point is that clearly he has some leeway on this. If Congress says here's $100 million and the Department of Education said, hey, we're going to give it to a convicted criminal to spend the money and they're going to spend it on buying those little rubber duckies that you see in Jeeps to give out to every kid, we'd say that's a waste of money. We're not spending that money. No one would object. And yet there seems to be a threshold here where Democrats are, well, it depends on what the money's being spent on is where the line is. And that's where I think the administration can argue it's clear that you wouldn't stop us on X, but you will stop us on Y. So there's and that's what I think their whole is. Again, I don't approach this from a legal standpoint, but more a common sense standpoint.
Sure.
That if the president didn't have the authority, then the argument could be great. Then you can't stop him from from preventing waste, fraud, and abuse.
So that's a really nice hypothetical, actually. I really like that. It's very illustrative. This notion
Rubber ducky.
Well, I actually meant the people like literally throwing money out the window, but I mean, but that does drive home the point, right? I mean, the president controls the executive branch, okay?
Right.
I mean, if you are an agency, you work for the president of the United States. I mean, there's all sorts of things that the Supreme Court is going to have to clarify here. This is just one of them there. By the way, the similar, very closely related notion, the so-called independent agencies. We saw the legal spat with Hampton Dellinger at the Office of the Special Counsel. Currently, there's a spat involving a Biden nominee to the National Labor Relations Board by the name of Gwynne Wilcox. The NLRB, the Office of Special Counsel, a lot of these so-called independent agencies are considered to be somehow outside of the Article 2 executive chain of command due to this misbegotten 1935 FDR New Deal era case called Humphrey's Executor. That's exactly the kind of case that I would expect this current Supreme Court to overturn ASAP. So there's a lot of work, frankly, that the Trump DOJ Solicitor General's office has to do in order to start teeing up a lot of these cert petitions to the justice there. But when it comes, again, to this bread and butter, here is the executive branch here. The executive controls the executive branch. I think there were at least 6 votes of the 9 justices to confirm that the next time they hear a direct challenge on the question.
So the story that I was reading you a minute ago goes on. It says in the second case, the administration wants the justices to green light a bid to fire 16,000 probationary workers at 6 federal agencies. Now, maybe there's a distinction between the type of employees. Probation employees are usually within a year of a new job or getting hired. And like a lot of places, they're probationary, meaning they have to adhere to certain standards or perform in a certain way in order to make that job. And so this might be a distinction that matters. I don't know. I want you to tell me. But when it comes to firing people, again, somebody doesn't show up for their job or light something on fire at work or commits a murder, you would say, of course, the president has the right to fire them. So where is the distinction when it comes to firing federal workers? Is it that they're probationary in nature? That matters. Is that he has to give certain people time? Like, what is it, if he's the head of the executive, that he has to do to have authority over the people who are being hired and fired?
Okay, so in my personal opinion, I do not think that the probationary distinction actually legally matters. I genuinely do not think so at all. So there's actually been a lot of legal scholarship on the question as to what the executive power actually entails. So Sean, you mentioned at the beginning that I'm here in New Haven. I'm speaking at Yale Law School today. There was actually a piece of scholarship in the Yale Law Journal over 2 decades ago, probably from the Bush administration period there. It was a co-authored article. One of the authors was a legal scholar by the name of Sai Prakash. And he basically goes back to the English common law and does a deep historical dive on what exactly the executive power entails in this article. And among the things that entails, really kind of the sine qua non. I mean, if the executive power reduces to anything whatsoever, literally anything, it reduces to personnel decisions, to hiring and firing within Article 2. That's kind of just common sense. If you don't have the ability to hire and fire whoever you want to, then you're not the executive. You're not the boss. Whether that's the presidency or whether that's a private corporation there, you fundamentally are not in control if those direct personnel decisions do not come to your desk there. So in my opinion, this probationary stuff, yeah, look, it's a distinction that has been drawn by a congressional statute or an executive order or a regulation promulgated pursuant to some White House counsel's office at some time there. That doesn't mean that it is constitutionally relevant, and insofar as it undercuts the executive power's plenary ability to remove officers that he does not like there, those statutes are probably all unconstitutional there. There's some very bad legal precedent on this because, again, this, like many areas, we've misinterpreted the Constitution for a very long time there. But I remain optimistic, frankly, that this is a court at the Supreme Court level that will actually reaffirm the original public meaning when it comes to this structural bread and butter separation of power stuff.
All right, let me just flip it real quick, and we have a lot to get to, but I just want to, like, if I'm a federal employee right now and I'm doing my job and I'm working hard and I'm show up for work every day and I do everything that I'm asked, do I have any protections against just being unilaterally fired?
Under prevailing statutes and literally late 1800s, 19th century civil service statutes and things like that there, yes. And frankly, these public sector employees oftentimes are involved in labor unions there. So there are private contracts. There are private contracts that people have voluntarily agreed to there when it comes to collective bargaining and whatnot there. But as a constitutional matter, it's just a constitutional matter, not holding aside the private contract. Constitutional matter, no, you have no protection whatsoever.
But I mean, I guess my point is, if I work, I mean, a lot of times, even in private employers, you're an at-will employee, but it says, hey, we'll give you 2 weeks, or you'll sign a contract and it says, hey, we'll give you 30 days notice. Do they, if you are literally just doing your job at the Department of Agriculture and they send you a notice and says tomorrow you're fired, do you have any recourse?
So honestly, candidly, labor law, not my forte. I don't know the exact details of the collective bargaining agreements that, for example, that Department
But
of
if you're
Labor
not
employee,
if you're not a union member, or do they all have to be?
The majority are at this point, but I don't think
Okay.
that you have an obligation to be there. But again, as kind of just a constitutional threshold matter there, you have no expectation to keep your job for any longer than what the executive wants to. Anything beyond that, it can be voluntarily agreed to between parties, but as kind of a public law constitution matter, there's no expectation of keeping your job for any indefinite period.
Okay. This idea, though, that all of these rulings are coming from district court judges, right? So they're shopping this up to like one of them in Rhode Island, and they're ruling, and then that judge in Rhode Island is affecting the entire country. There's some talk about whether or not that makes sense, whether it should be reined in. Where do you come down on this idea that district court judges should only have authority to rule over the district that they preside in?
So this, I'm very happy you asked this question. This is the single most important legal question that is currently facing the country right now.
And I asked it.
Yeah, and you asked it. This is the number one most important question. There are a lot of important questions, birthright, citizenship, a lot of important stuff going on. This, what you just asked right here, is the most important question. Because when you allow district court judges, lone judges, to issue rulings that purport to bring the entirety of the executive branch to a halt there, you are no longer living in a lowercase r republic. You are living in a juristocracy. You're living in a system of unmitigated judicial supremacy, the likes of which America's greatest statesmen throughout our history recognize would fundamentally be incompatible with the founding. I mean, Sean, my single favorite figure in American history, Abraham Lincoln, understood this actually better than anyone. After the infamous Dred Scott case, where Chief Justice Roger Taney horrifically ruled that Black people were not citizens and could never be citizens, Lincoln famously said in his debates with Stephen Douglas in Illinois the next year that if he were in a position of power, he would respect that judgment as it pertains to the named parties to the lawsuit, aka Mr. Scott himself, Dred Scott, but he would not extend it a millimeter further. And then when he was president, Abraham Lincoln, he issued passports to Black Americans in the Western Territories of the United States in direct defiance of the Dred Scott ruling. And that was a Supreme Court ruling, actually. That wasn't even like a lower district court judge ruling there. But the relevant legal question is, what does the judicial power mean? We were just talking about Article 2. What does the executive power mean? The relevant question for purposes of these so-called nationwide injunctions is an Article 3 question. What does the judicial power mean? Fortunately, Sean, we actually know the answer to this. So I kind of nerded out with a law review citation a few minutes ago. I'll do the same thing. I'll do the same thing here. Sam Bray, one of the absolute greatest conservative legal scholars in America right now. I think my alma mater, University of Chicago Law School, actually just hired him. Tremendous hire, actually. But he had a law review article for the Harvard Law Review back in 2017 during the first Trump term, making an extremely compelling case that the so-called nationwide injunctions far exceed the boundaries of what courts of equity in England used to do. It would have been radically, radically outside the bounds of what the judicial power meets in our Constitution. The power of a court to issue a judgment is to bind the parties to a lawsuit. You cannot go anything beyond that whatsoever. So not only, in my opinion, are these nationwide injunctions unconstitutional there, I am extremely dubious of the notion that district court judge could frankly bind anyone, even in his district, actually. To me, the judicial power entails the ability to issue a ruling for the plaintiffs. Anything beyond that is persuasive authority, perhaps.
So if you're Trump, do you just say, hey, I listened to Josh Hammer on Sean Spicer's show. I think we just go forward until the Supreme Court or a higher court enjoins this, because that only applied to the folks in Rhode Island or whatever.
If I were whispering in Donald Trump's ear, that's exactly what I would say. And that was my very first thought, by the way, as well. When the first anti-birthright citizenship ruling came down from that judge out in Seattle, Washington, my very first instinct was like, okay, if I were advising President Trump, I would say, you can listen to this ruling as it applies to the literal plaintiff in this case there, but don't extend it a millimeter further than that.
Okay. Your time is valuable because you got to go talk to these kids at Yale and get them straight. And that's critical because they are the future of this country. So let me just hit on a couple quick issues. You talked about birthright citizenship. What don't I get about that amendment? Because right now, the way I read it is, hey, you're born here, you're born here. That's it. But I also look at the fact that diplomats, if their kid's born here, they're not, because they weren't in keeping with our laws, is I think the way it phrases. Why do people have a belief that birthright citizenship shouldn't be granted if you're in the country illegally?
So this is one of my favorite legal debates. Back when I was chairman of my conservative debating society in law school, Sean, I actually chaired a debate on this exact question. So I happen to love this debate.
Good.
So the debate comes down to what the meaning of the phrase "subject to the jurisdiction thereof" in the citizenship clause of the 14th Amendment means. So the purpose of the citizenship clause is to overturn the Dred Scott case of 1857, and it fundamentally was meant to apply to Black citizens. That itself, I think, is actually important to note at the outset here, because it did not apply to American Indians, for instance. We actually had to wait until the Calvin Coolidge presidency. There was a statute that Congress passed in 1924 called the Indian Citizenship Act. That was the first time that the children of American Indians were automatically entitled via congressional statute to birthright citizenship, because the idea was that the American Indians were not subject to the jurisdiction in a whole political allegiance sense of the term to the United States of America there. And the other thing that I think is worth noting here about the 14th Amendment is that the purpose of this amendment was to constitutionalize the Civil Rights Act of 1866, a very important statute there in the early Reconstruction era, but it was on constitutionally dubious grounds. So the amendment 2 years later, all the people who basically drafted this amendment, Senator Jacob Howard of Michigan, Lyman Trumbull of Illinois, they were very clear. They were just trying to constitutionalize the statute 2 years prior. And then you can go back and look at the citizenship clause in that statute. And instead of this more amorphous, kind of legally unclear, subject to the jurisdiction thereof language, that statute used the much clearer language of not subject to any foreign power. So that is kind of the relevant legal question here, is that if you are subject to a foreign power, are you automatically inherently granted birthright citizenship under the 14th Amendment? And I answer that question, no. Now, that does not mean that Congress cannot statutorily grant that if they want to there, but as a constitutional baseline threshold matter, I have long been sympathetic to the view that Donald Trump has since put into his executive order, that if you are subject to a foreign power, i.e. you're a citizen of a foreign country, you came here illegally and so forth there, you're not a citizen, you are not automatically, as a constitutional matter, entitled to birthright citizenship for your children.
I love it. To me, I actually want to hear, I'd like to hear your whole debate some point, because I'm fascinated by this question. But I have two more quick things. I know your time is tight because you got to go get these kids straight. But two quick things. Number one, the AP is suing the White House, saying they have a right to be in the pool, the press pool in the White House, to go into the president's office, to ride on the plane. How does the court ultimately rule against, or who do they rule for and against in this AP versus the White House case?
Yeah, this is a totally frivolous lawsuit by the Associated Press. I mean, I can't even say that with a straight face, honestly. I mean, it's laughable. I mean, there's no First Amendment right for any particular media organization to
Right.
get any kind of specific access there. The First Amendment literally means the government cannot seize your printing press. That is what the freedom of the press actually means. It doesn't entail you to any sort of specific access point or any interview or Air Force One. I mean, get out of here. It's absurd on its face, honestly.
Okay, I agree. That's where I come down on this. You don't have a right to go to somebody's office just because you have a press pass. And frankly, I think that the idea that anyway, I'll save that so far. The last question I have for you: the president and the White House are getting some pushback on some of the people that they've deported and sent to El Salvador. And again, regardless of the merits, the White House, Caroline Leavitt, yesterday illuminated the fact that this gentleman from Maryland might not be the good guy that the Atlantic and some of the media are making him out to be. In fact, a member of MS-13, had previous issues, et cetera, et cetera. The bottom line I want to ask you, though, is if you are deported like this, regardless of the fact that you're in the country illegally, do you have any? Do you have the right of due process?
No. Full stop, no. And there's literally direct, unambiguous case law on this going back 200 plus years. My favorite citation for this point comes from Justice Robert Jackson, one of the great 20th century Supreme Court justices. Sean, he actually was the dissenter in the Korematsu case, in the Japanese internment case in 1944 during FDR's presidency. He dissented on due process grounds, and he was considered to be the great champion of due process because of that. But 9 years after Korematsu, in a case called Shaughnessy in 1953 there, Justice Robert Jackson writes very, very, very clearly, due process does not entail the right of any alien outside America's borders to come here against the national will, nor does it entail the right of any alien once you are here to remain here against the national will. There is no due process right to remain in this country, whether you are a legal or illegal alien. I think that's actually the key point here. Now, again, Congress can, of their own volition, of their own beneficence, let's say, they can statutorily create due process procedures. In fact, Congress has actually done that at times there. But as a constitutional matter, there is no due process right whatsoever to remain here if we, the people, decide that we don't want you to be here. It actually goes even further than that. I would actually argue that when it comes to the political branch's ability to enforce this nation's immigration and sovereignty laws, Article 1, Article 2, that Article 3, the federal courts, actually cannot get involved. Traditionally speaking, immigration law was not even considered to be justiciable. It was not even considered to be an area ripe for judicial review. In fact, the very first time the Supreme Court ever struck down an immigration enforcement statute, believe it or not, was just a few years ago, in the year 2018, a case called Sessions versus DiMaia. It was actually a wrongly decided case. But that just goes to show you that the courts just never got involved in this stuff for the vast majority of America's history there. And then that's true. And then also on the narrow question of due process, no, there's absolutely no due process right to remain here against our will.
Are you debating or speaking today?
I did debate actually for the college kids at Yale last night, and say I'm just speaking on the pro-life issue, actually.
Dude, I feel bad for the guy that had to debate you, or the woman, because I love listening to you. Just the way that you can cite chapter and verse these cases, to me, makes me feel so bad for the sucker that had to debate you, because I'm sure they got up there and said, well, the Constitution said, and then you're going, yeah, in Sullivan v. Jackson, 1942, the justice. I mean, dude, I would love to be there. I would love to stream a debate that you're having with someone anytime, because it just, to me, would be a masterclass in how to get your butt whooped. So, Josh, I appreciate you making time for us. Get some pizza there in New Haven, and look forward to having you back soon.
Thanks so much, Sean. I appreciate it.
You bet.
Well, if you enjoyed this content, make sure to like this video, subscribe, and click the notification bell to get more.